Welcome to the 31st Annual Bainbridge Moot Court Competition. First of all, I would ask you to please turn off all cell phones, pagers, beepers, any electronics that make noise. Please turn them off. In the spring semester, because most of you are first-year students in legal process 2, you will be writing an appellate brief, and then you will be doing an oral argument on the problem. Moot Court is a national and international exercise where teams from each school, intramural, and today you're seeing the intramural competition, compete. The difference between what you'll be doing in the spring and what happens in real life as opposed to moot court is the students have to argue both sides. They write a brief for one side, but they have to argue in the preliminary rounds both sides. And then we did that a week ago Sunday. 4 students were chosen as semifinalists based on their brief scores and their oral scores, and the 2 finalists will be arguing today. Pay attention because you're going to be doing this in the spring semester, and this is what lawyering is about. We have a distinguished panel, and so I welcome all of you, and at this time I would like to introduce Christina Knorr, the editor-in-chief of the Moot Court Honors Board of Advocates, and last year's Bainbridge winner.
Thank you, Professor Silverman, and good afternoon. On behalf of the entire Moot Court Honors Board, I would like to welcome you all to the 31st Annual Bainbridge Moot Court Competition. Today you will be hearing our 2 finalists, second-year students, Sidney Goldstein and Jason Prince, present an oral argument before a panel of highly esteemed judges who will be acting as the United States Supreme Court. Both Ms. Goldstein and Mr. Prince have worked extremely hard for this day. The case they will be arguing deals with the ministerial exception. This exempts religious institutions from anti-discrimination laws. In this case, the respondent, Paul Kelly, was fired from his employment as an organist within the church, Our Lady of Snow, after reporting child abuse. He commenced an action claiming that he was fired in violation of a mandatory reporting child abuse statute. The petitioner, Our Lady of the Snow, will be arguing that the ministerial exception is a defense to Kelly's claim, while the respondent will argue that the ministerial exception does not apply. There are 2 issues before the court today. First is whether Paul Kelly is a minister within the meaning of the ministerial exception, and second, whether the church is subject to the retaliation provision of the mandatory child abuse reporting statute. At this time, we will proceed with the oral arguments, and we hope you enjoy our presentation. Thank you for coming.
All rise. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Which one is this? I think we're over here. All right, everyone please be seated. You got the right one. All right, it's our privilege to be here for this important event. And at this time, I understand, Mr. Goldstein, you are representing the petitioner, and you are to go first. Is it, oh, Sidney Goldstein, I'm sorry. Is it Sidney?
Yes, Your Honor.
My apologies. Your name is interchangeable. Yeah.
Good afternoon, Your Honors. May it please the court. My name is Sidney Goldstein, representing Petitioner, Our Lady of the Snow. At this time, Petitioner respectfully requests 1 minute for rebuttal.
All right.
Thank you, Your Honor. This case is about interference of the church's constitutionally protected doctrine and the violation of its policy, which damaged the reputation of the church. Your Honors, today, Petitioner respectfully requests this court to reverse the decision of the 12th Circuit Court of Appeals for 2 reasons. First, Paul Kelly is a minister within the meaning of the ministerial exception. Second, Our Lady of the Snow is exempt from Torovia's mandatory reporting statute.
What is the history to the minister exception? Where does it spring from? How long has it been around, and what is its origins?
Your Honor, it comes from the First Amendment. It's right under the First Amendment. It was officially adopted by the Supreme Court last year in 2012 in the case of Hosanna-Tabor Evangelical Lutheran Church versus EEOC.
Yeah, but that involved a teacher, that case, and somebody who was really indoctrinating children with religious component. Here we're just talking about he's not even a choir director. I know there are some cases where choir directors have been involved, but this was just an organ player.
Your Honor.
How could he be a minister?
Your Honor, he is considered to be a minister because music is essential to conveying the church's message, as stated on page 3 of the record. Your Honor, the fact that Mr. Kelly was...
But he didn't have any real training as a minister or in a religious training. He just learned to play the organ.
Justice Freedman, Mr. Kelly did have extensive religious training as an organist. And in Petitioner's religion, the organ is essential to conveying the church's message, which rises Petitioner...
What training did he have, religious training did he have in terms of the organ? Didn't he just take just one course while he was at Crane?
Yes, Justice Freedman, he did take a course called Music in Religion.
However, most organ music is religious music, but what he learned was to play the organ.
Absolutely, Your Honor. And the fact that organ and music is so essential to conveying the church's message, Petitioner felt that Paul Kelly's religious training rises to that of a ministerial position. Your Honors, furthermore, in the case of Canada versus...
Was he referred to as a minister in the church by congregants or by other employees of the church?
No, Your Honor, he wasn't explicitly referred to as a minister. However, in Justice Alito's concurring opinion in Hosanna-Tabor, he stated himself that most faiths do not employ the term minister. And in fact, some...
Well, that wasn't a concurring opinion, but the main opinion talked about the minister.
Yes, Your Honor.
Exception.
However, in ambiguities of a majority, the concurring opinion can help a court further determine what was meant in the majority opinion.
Let me ask you this. You have cases bouncing all over the place here. Some for, some are against, some support, some do not support. I guess this is proper meat for the Supreme Court to try to resolve this. So you have this balancing of interests. You have these various factors that are trotted out by the Supreme Court, by other courts. Is there any one or two factors that you think should dominate, should have greater weight than others? I'm just trying to figure out how we can get a handle on this to give proper guidance to the lower courts.
Your Honor, no one factor or two factors should be determinative. This court stated that they took all factors of an individual's employment into consideration. However, in terms of the factors decided upon in Hosanna-Tabor, the petitioner would argue that factor where he performs important religious functions weighs very heavily on our side. Furthermore, the fact that no other lay persons performed respondent's duties, and the fact also that the amount of secular duties he performed versus the amount of non-secular duties he performed are the factors that would be considered most important.
Shouldn't any lay person play the organ? And isn't that, in fact, why he was asked to play the organ? Because he was a musician and he knew how to do it and there was nobody else around?
Your Honor, initially that was the fact of the matter. As stated on page 2 of the record, Mr. Kelly was an emergency fill-in because the previous organist, Robert Locke, had in fact passed away suddenly. However, after playing for the 2011 Christmas Mass, Paul Kelly showed the church that he was an outstanding organist. And in fact, as stated on page 3 of the record, Robert Lewis, the choir, music director rather, invited him to play for the Saturday choir rehearsals. Your Honors.
But he was noted as a musician and as an organist, not as a minister.
Your Honor, initially yes, but through the other factors considered, he is considered a minister within the meaning of the exception. The fact of the matter that the church actually compensated him shows that they deemed him to be an essential employee within the church.
Well, would a secretary who the church compensated who just did secretarial work be a minister?
Your Honor, her performing merely secular duties would not rise to the level of being a minister. However, in this case, Paul Kelly performed strictly non-secular duties. He was only supposed to perform 2 days a week, Sundays and Saturdays, playing the organ. Your Honors, music, as stated on page 3 of the record, Reverend Duncan stated that music is essential to conveying the church's message. And furthermore, when Paul Kelly informed Robert Lewis that he was unable to continue volunteering with the church because he had to recover from Hurricane Sandy damages to his home, the church could have easily said, "Thank you so much for your time, Mr. Kelly. We will find another volunteer for your position."
Has any court found an organist to be a minister? Because one of our sister courts, as you know, in Maryland, has found that an organist is not a minister.
Your Honor, in your reference to Archdiocese of Washington versus Morrison, that case is distinguishable from the case at hand. Although the plaintiff was an organist, Your Honors, there was no evidence in his record that showed that he
I think the question is whether there are any courts that have flipped the other way around.
I apologize, I misunderstood, Your Honor. Yes, there is cases that rule in our favor. In fact, in the case of Canada versus Catholic Diocese of Austin, a Fifth Circuit Court case in 2012, it was found that is very similar to the case at hand. Like the plaintiff in Canada, Your Honors, Kelly responsibilities to the church were to accompany the choir during choir rehearsals and to play during Mass.
Is there any common theme that, is pervasive here? I mean, I guess I'm hung up on the fact that all the poor lower courts are going to have to look at all these disparate facts and somehow come out with some determination. Can we give better guidance than just, put it in a cocked hat and decide what you want to do on a case-by-case basis? Should there be some uniform theme or themes here that unite these cases?
Your Honor, every religious institution throughout this country has a different means of whom they consider to be a minister and whom they don't. To pick a flat-line test, it would potentially prejudice those religious institutions who aren't similar to the one represented today. However, Your Honor, the fact that the respondent performed strictly non-secular duties in this case is very good proof to show that he was considered a minister within the church.
Did the church here consider him to be a minister?
Yes, Your Honor, they did. As stated on page 3 of the record, when Mr. Kelly was trying to seek part-time and paying employment, the church could have said, "Thank you for your time, we will seek somebody else to volunteer." However, on page 3 of the record, it states that they did actually compensate him. And Reverend Duncan stated himself—
Are you saying that compensation is what determines who a minister is and who is not a minister?
Your Honor, no one factor can be determinative. However, the fact that, as stated on page 3 of the record, Reverend Duncan said that only those employees who are able to be compensated are those who are essential to the church and for whom the church could not afford to lose. Your Honors—
Isn't it true that Reverend Duncan wanted to have this position filled by a volunteer?
I don't believe the record states that he wanted his position to be filled by volunteer. However, Paul Kelly was a volunteer initially.
He wanted Paul Kelly to stay as a volunteer, didn't he?
I'm sure the church would have preferred that. However, the fact that he was compensated shows that he was an indispensable employee for whom the church could not afford to lose.
Reverend Duncan's outlook that only people who are essential should be paid and that the organist was not an essential person? Isn't that what the record reflects?
Your Honor, he was an essential member of the church and for whom was able to be compensated because he was such a core function and considered a minister by this court. However, no one factor—
you have a limited amount of time. Perhaps you want to go on to your second issue so you don't cut yourself short.
Thank you, Chief Justice Block. As a petitioner's second point, Your Honors, petitioner is exempt from Touro-Via's mandatory reporting statute since its compliance would interfere with petitioner's right to—
Well, he may be exempt, but isn't it against the law? Isn't sexual abuse against the law? Aren't we dealing with a legal issue now and a criminal issue or potential criminal issue?
Yes, Your Honor. And in fact, Mr. Kelly was a mandated reporter under the statute. Under Section 413A, it lists a school teacher as being a mandated reporter, for which Mr. Kelly did teach at Cairo's Public High School full-time. But
that wasn't his role at the church.
No, it wasn't, but he was, under the statute, you have to report in your professional or unprofessional capacity. Your Honors, as stated in 413A of the statute, it states that a mandated reporter must either report or cause a report to be made. Your Honors, when Mr. Kelly informed Reverend Duncan of these allegations, he in turn caused a report to be made. Since Reverend Duncan reported to CPS And also the church conducted their own internal investigation, Your
He
Honor.
was fired because he discharged his statutory obligation to report this abuse? Is that why he was fired?
Absolutely not, Your Honor. He was terminated because he violated church policy. As stated on
The church policy being what specifically here?
Your Honor, as stated on pages 3 to 4 of the record, the policy as stated by Reverend Duncan was to preserve a harmonious religious community.
But he had an obligation. I guess he could be criminally prosecuted under statute, correct, if he did not report.
Your Honor, he absolutely did have an obligation, and he fulfilled his statutory obligation when he informed Reverend Duncan, the head of the church, which caused a report to be made.
Reverend Duncan did not inform him, did he, that a report had been made? And shouldn't Reverend Duncan have informed him that so that he then knew that his statutory duty had been discharged?
Your Honor, as stated on page 3 of the record, Reverend Duncan informed Paul Kelly that he would handle the matter immediately.
Doesn't he have to report to the child services? I mean, what exactly does the statute say in that regard as to who he's obliged to report to?
Your Honor, the statute is void as to whom the mandated reporter
It's
is
silent.
supposed to.
He has an obligation to report to whom?
Is either to report or to cause a report to be made. The statute doesn't officially state whom the report is to be made to. However, in either instance, Your Honor, he caused a report to be made to the proper authorities, considering Child Protective Services is deemed to be.
The Supreme Court case, Hosanna, which I think to some extent you're relying on, said that we're not saying that the ministerial exception applies to everything, and particularly where criminal activity is involved. So wouldn't you say that this is the kind of thing that the Supreme Court was saying that the ministerial exemption might not apply, or exception might not apply to?
Your Honor, the ministerial exception under Hosanna-Tabor was found to apply in that case only to employment discrimination claims. However, the court said that upon its opportunity that they would rule to see if they should extend.
Well, you want us to expand that to cover this failure or the report of sexual abuse. Isn't there a far more serious concern with that sort of activity, which would justify carving out an exception to Hosanna?
Your Honor.
And an oral argument, didn't counsel for the church in Hosanna concede that would justify carving out an exception?
Yes, Your Honor. However, that was one petitioner one lawyer for a single religious organization making that assumption. Your Honor.
And also, didn't one of the justices talk about that as a possible problem?
Yes, Your Honor.
Justice Sotomayor?
Yes, Your Honor. And that is a possibility. However, there's no evidence in the record to show that petitioner in any way, shape, or form did not comply with the statutory obligations, or that they had any bad faith in terms of trying to conceal this child abuse. Your Honors, petitioner complied, and they went above and beyond by...
That would become an issue of fact, whether Kelly just did what he was supposed to do and is getting fired for that, or there are other reasons why Kelly is being fired. But how do you justify extending Hosanna to this sort of conduct? I mean, this goes as fundamental protection of children. How do you say that there's going to be an exception for that?
Your Honor, I see my time has run up. May I briefly answer your question and conclude?
Yeah.
Thank you, Your Honor. Your Honor, the exception being extended to these type of cases has the same implication as a employment discrimination case. In either way, the court would be inflicting comparable harm on religious institutions, and that would be the deprivation of the freedom to appoint and the right to shape the church's own faith and own mission, Your Honor.
All right.
Your Honors, petitioner respectfully requests this court to reverse the decision of the 12th Circuit Court of Appeals and to reinstate the decision of the District Court.
All right.
Thank you.
You have your 1-minute rebuttal that if you want to use that, you can, Mr. Prince.
Good afternoon, Your Honors. May it please the Court. My name is Jason Prince, and I represent the respondent, Paul Kelly. Your Honors, there are two reasons why this Court should affirm the judgment of the United States Court of Appeals for the 12th Circuit. The first reason, Paul Kelly is not a minister. And the second reason, is that neither this church nor any other religious body is exempt from complying with society's child abuse laws. As to the first issue, Your Honors, in Hosanna-Tabor Evangelical Lutheran Church versus EEOC, this court laid out 6 factors to consider when determining whether or not an individual is a minister. The first factor that this court looked at was whether or not that individual was given a formal title. And in the case at bar, Paul Kelly was never given any title.
So how do you go about doing this as a judge? You just look at each of these factors individually and say whether this one is up or down? I mean, the same type of question I asked your adversary. What kind of connecting linkage can we look to? Is there some unifying concepts here or something that dominates one more than the other? One of the obligations I think we have is to give the lower courts a little guidance. What guidance do you give them here? Just every one of these things are factually intense and we can't do more than just trot out these factors. Are there any other factors that should be considered? Is this an exclusive list of factors? Are some more important than others? Give me some sense as to what kind of guidance we can give the lower courts.
Absolutely, Chief Justice Block. And this court actually did give guidance to the lower courts that they have since used in their analysis. And that guidance was that there is no rigid formula and that there is no one factor that can either be viewed in isolation or dispositive by itself. Rather, all 6 factors that this court looks at are weighed against each other.
Well, some of the factors, though, clearly do apply, don't you think?
I'm sorry, Your Honor. Apply in terms of this case?
Apply to Mr. Kelly, Paul Kelly.
Absolutely, Justice Freedman.
Could a spiritual leader be considered somebody that functions like a minister?
Yes, Justice Salkin. And that spiritual leader would be put through the same test. Those 6 factors would be analyzed in terms of that spiritual leader, and then a conclusion could be made. But just
So which of the factors that you think supports your adversary's position?
Your Honor, the factor that best supports my adversary's position may be the fact that he had religious duties in the church, and those religious duties were playing the organ. However, that factor barely supports the petitioner's position.
What
Well,
about the fact that he led the choir on occasion?
Your Honor, that is one of the factors that courts look at in determining whether or not the individual performed important religious functions. However, Paul Kelly performed at the rehearsal on one occasion as a substitute. And when he did so under the complete direction of his superior, of the music director, Robert Lewis. And there's a common denominator that lower courts have held. And that denominator lies in the fact of the gravity and the regularity of the important religious functions the individual is performing.
So let me ask you this. So we have 6 factors. We add them up. A 4 tip in your favor, you win. A 4 tip in your adversary's favor, she wins. Is that how we do this?
I'm sorry, Your Honor?
We add up these 6 factors, and 4 are for you, so you should win. But if 4 were for her, she should win. Is that what we do? We just add up these things numerically?
No, Chief Justice Block. Rather, this court should weigh each of the factors, see how significantly one of them might favor one certain side, and then...
Well, which ones do you think do not apply to Mr. Kelly? Maybe I'll ask it that way.
In terms of him not being a minister?
Yes.
Absolutely, Your Honor. The fact that he was not trained. His entire list of training consists of one course he took in college, a music course.
Well, but he was trained to be an organist, and organs are usually played in churches, aren't they? So most of his training probably involved some religious music.
Precisely, Your Honor. He was trained to play church music because most organ pieces are church music. In fact, he hadn't even attended church since he was 14 years old up until recently. And organs are also played in every hockey arena in the country. It's also played on Broadway, and accordingly, as the court in Archdiocese of Washington versus Morrison stated, there's not just any type of training that the courts look for. They're looking for...
Doesn't music become a core part of the service, and the person who's playing or providing that music, isn't that part of the religious service?
It absolutely is.
Doesn't that make him a minister?
No, Justice Freedman, because the courts have drawn a line into how much an individual who contributes to music at Mass has to do before they are considered a minister. And that line rests in the autonomy and the unilateral decisions that they make. As in Canada versus Archdiocese of Austin, that individual chose all the hymns and songs that he played, unlike Paul Kelly, who was under the strict supervision of his superior, Robert Lewis. He had no control over anything he played, and if he played with a different tempo or a wrong style or beat...
What if he was trained to be a minister, but the functions that he was performing in the church only dealt with playing the organ once a week or whatever? Would he then be a minister?
Chief Justice Block, that would be a determination that's left up to this court. Perhaps he would be a minister based on the other factors that this court would analyze. However, the fact that apparently the individual is a minister, would certainly weigh in favor of the conclusion that he may be considered a minister.
What are some of the other factors that you think do not apply to Mr. Kelly?
Justice Freedman, the factor that Paul Kelly was not commissioned greatly supports the conclusion that he's not a
Well,
minister.
is that arrogating form over substance? I don't understand what that means. Commissioned by whom? As what? I mean, somebody waves a wand and says you're a minister, you're commissioned?
No, Chief Justice
Put some
Block.
meat to the bones there. I don't understand that.
The best way to compare it is to look at this court's decision in Hosanna-Tabor, where that commissioning process involved the respondent having to go through a strict regimen that culminated in her receiving a diploma or certificate after completing religious training that designated her as a commissioned minister and certified that she had been called by God to teach and to lead at that church. Again, none of these factors are present in this case.
What if that person went through that training, but somehow this person was the janitor, and he never really was functionally acting as a minister, but he had all those credentials, and he was actually commissioned? It may be an extreme, example, but I'm trying to give you an extreme example to see how you would rationalize that.
Certainly, Your Honor, and that's why it's great that this court laid out 6 factors in Hosanna-Tabor to consider. So just because he may have been commissioned does not mean that he was trained, that he had a formal title, or as you stated, he did not have any religious duties, and all of those would weigh against the one factor that does support him.
Isn't singing in a house of worship religious exercise?
Absolutely, Your Honor.
So somebody who would be leading that singing by music or leading the choir, they wouldn't be a leader of religious exercise?
That is one of the common themes that courts have held. If you are leading, if you have authority, if you choose the songs and the hymns that are played, then it's likely that you are a minister.
Well, shouldn't we essentially adopt some sort of a functional approach and sort of, use the old standard, not arrogating form over substance? Some of these things seem to be formulaic, and some seem to have more of a substantive kick to it. Shouldn't that be the type of thing we should really look for in terms of what dominates?
In terms of one individual factor, Chief Justice
Well,
Block?
a couple of factors. I mean, I look at the functional aspects of who cares what his training was before? Who cares what he did in kindergarten or in high school? He's at the church right now, and he's performing church duties. I mean, what difference does the past make?
Well, one of the factors that, aside from the 6 this court laid out, that courts have looked at is whether or not he was regarded as a minister, or whether or not the individual held himself out as a minister. And nothing in the record supports that conclusion. Paul Kelly never thought of himself as a minister. He's never once been referred to as a minister. And as page 2 of the record shows...
Well, but as your adversary said, and as Justice Alito, with Justice Kagan's concurrence, also said that the concept of minister is not really where it is, because in so many religions, minister doesn't have a specific meaning. It's the function, and here he is leading the choir at least once. He is playing the organ religiously, every week, and he is purveying what is most important in a church, or very important, and that is the music.
Some of those things are true, Justice Freedman. However, courts have again drawn a line in this area as well. And regularity is the important function of whether an individual is a minister or just an employee of the church.
One of my responsibilities is to move everybody along here. So why don't you deal with the second issue now before you run out of time?
Yes, Chief Justice Block. With regards to the second issue, Your Honors, neither this church nor any other religious body is exempt from complying with society's child abuse laws for 2 reasons. Number 1, the church erroneously states that this court's decision in Hosanna-Tabor barred all types of suits, but as this court stated itself at the end of its opinion, that case only barred employment discrimination suits, and this is a retaliation claim of a child abuse reporting statute, something completely opposite.
Well, didn't he act a little high-handedly by going to the authorities after he'd reported it to the minister and not inquiring, at least, of Reverend Duncan as to what he had done? And then he would have ascertained, of course, that a report had been made and an investigation had been made.
Not at all, Your Honor, because number 1, Paul Kelly did actually go back. He did seek out Reverend Duncan, and he sought him out for the sole reason of asking him whether or not something was being done in the investigation, and he was repeatedly rebuffed. He went there on 2 occasions, including...
Isn't it confidential about what kind of investigation is being done internally? Wasn't his job done when he made that official report?
Yes, Your Honor. However, Paul Kelly was then presented with a conflict. He had to choose whether he wanted to comply with church policy, not knowing that any investigation was being done, or he could break the law and know that child abuse could still be continuing while he had inaction. He could not sleep at night if he made that type of decision, and society did not want him to make the decision to simply sit back and wait for the church to finally come to him and say that they were doing something about it. So he
Also, in this case, all he got was the hearsay report from somebody else who said he saw something. Was this enough for him to go and violate church policy and go outside after having made the report to Reverend Duncan?
It certainly was, Your Honor, because the statute does not require that the allegations actually be proven. The statute requires that the mere existence of allegations commands a person of Paul Kelly's occupation to go to the proper authorities and to report them so that they can conduct an investigation on their own.
Yeah, but what is the operative principle here? Isn't the principle is that the court is not supposed to be looking behind the reason why the church fired Kelly?
Yes, Your Honor. However, Paul Kelly is asking that if one instance of sexual abuse can be prevented and the only sacrifice that needs to be made...
Well, look, it's not the same, of course, but if employment discrimination can be prevented, that's also important. And nevertheless, we've said that employment discrimination, the church cannot be told what to do by the courts.
Correct, Justice Freedman. However, the best way to distinguish that, or the overwhelmingly distinguishable trait, and that with regards to that question, is the fact that this court has repeatedly upheld that protecting the well-being of children is of a surpassing importance to First Amendment protection.
So you say that this should be an exception, clearly, right? And what other exceptions, have any, have been carved out by maybe the lower courts or even by this court inferentially or implicitly? Then also, when you're thinking about that, how does one determine what should constitute an exception to the rule?
Well, with regards to your first question, Chief Justice Block, this court in 1982 in New York versus Ferber actually did carve out one exception. In that case, there was a child pornography statute that an individual claimed violated his First Amendment rights to freedom of speech.
What standard do you employ in determining whether something should qualify as an exception?
Whether or not, this court has recognized that a balancing test is conducted.
Is another a different balancing test here to determine what should constitute an exception?
Maybe not to constitute an exception, Your Honor, but it would certainly follow that that could be the case, because this court does weigh the interests of one side against the interests of the other. And in this case, it's the interest of protecting the church's First Amendment rights against the interest of protecting children from sexual assault. And as this court and others below it have repeatedly upheld, society's interest in protecting their youth from sexual assault is of a surpassing importance that easily, to quote this own court, that easily transcends the First Amendment protection.
So those are the only exceptions we have, the child pornography and arguably this case. Are there any others that have been carved out?
Yes, Chief Justice Block. In fact, since Touro statute is a neutral law of general applicability, the church cannot even say that Paul Kelly's claim cannot be adjudicated. The courts have held in Balaban versus Bloomington Annual Conference that neutral laws of general applicability apply to everyone. The church is not immune from them, and accordingly, they cannot violate child abuse reporting statutes.
I'm sorry, what are you saying? Balaban, the court upheld the firing of the rabbi in that case, who claimed that he was fired because of reporting sexual abuse.
Precisely, Your Honor. However, the information about the neutral law of general applicability does still come from that case, and the difference between why that individual was fired was because he actually had several other reasons of why he was fired. He was insubordinate, he caused them to try to evade taxes, and he committed several other employment violations.
So you're saying that there's a tax exception or other criminal violations of criminal law could be an exception? Is that what you're saying?
Violations of criminal law should certainly not be covered by this court's holding in Hosanna-Tabor.
If Mr. Kelly had a legal duty to report, as you say, to the state authorities, then why did he report to the Reverend first, and why did he wait so long if he felt the weight of having to report to the state?
Justice Salkin, Paul Kelly reported to Reverend Duncan because that was his superior and it's the first person that he came across upon hearing about these allegations, and he did not wait very long. I'm sorry, Your Honor, I see that my time has concluded. May I briefly finish your question and conclude?
All right, I think you answered your question. We have 1 minute rebuttal by your adversary, if you'd like to do so at this time.
Thank you, Your Honors.
Get rebuttal, too. Get rebuttal. I don't think he gets rebuttal.
Your Honors, Respondent argues that this court should allow the First Amendment to be transcended by the statute. Your Honors, there's no evidence to show that the church did not comply with the statute. Furthermore, in Hosanna-Tabor, it was stated that by inquiring into whether the church had followed its own procedures, our court will have unconstitutionally undertaken the resolution of quintessentially religious controversies, whose resolution the First Amendment commits exclusively to the church. Thank you, Your Honors.
All right, thank you. The court's in recess at this time.
All rise.
Yeah, I think she's at the other end.
All right, please be seated.
We came in the wrong. Oh.
Everyone be seated. We're welcoming Judge Stong here, and she unfortunately didn't leave New York City till 8:30 this morning, so it took a little while to get here. And she feels very badly about that. But, you know, when you come from New York City, sometimes these things happen. I'm told that the protocol here is to give us... Yeah, I'm sorry. Did you say...
Judge, we're going to have a little program first,
Yeah.
and you're part of the program, though. Let me introduce Christina Knorr, who is the editor-in-chief of Moot Court once again.
Thank you, Professor Silverman. At this time, I would like to introduce our panel of judges. We have the Honorable Elizabeth Stong from the United States Bankruptcy Court for the Eastern District of New York. The Honorable David Freedman from the New York State Appellate Division for the First Department. The Honorable Frederic Block from the United States District Court for the Eastern District of New York. The Honorable Helen Freedman, also from the New York State Appellate Division for the First Department. And Patricia Salkin, Dean of the Touro Law Center. On behalf of the entire Moot Court Honors Board, we would like to thank you for coming, and we are extremely happy to have you here. Thank you. At this time, I would like to introduce the members of Moot Court, starting with the editorial board. If you could all please rise. First, I would like to thank the e-board for all of their hard work in preparing for this event and all of their dedication throughout the entire year. We have Laura Johnson, the Associate Editor-in-Chief for the Day Division. Paul Lipsky, our Research Editor, and also the writer of The Problem. Angela Puglisi, the Program Editor. And Pavlo Pavlatos, the Associate Editor-in-Chief for the Evening Division. And Dina Melchiori, our competition editor, who organized this event. Thank you. Now I would like to ask all of our senior and junior members to rise to be recognized. I would like to thank all of you for your hard work in preparing for this event, and it would not have been as wonderful as it was without each and every one of you, so thank you. I would also like to recognize our faculty advisors. Our faculty advisors provide us with incredible support each and every year. They help us prepare for every competition and continually give us incredible amounts of their time. We contribute a large part of our success to them. We have Professor Louis Silverman, who also helps us with Bainbridge. Professor Heather Melniker. Dean Myra Berman. And Professor Thomas Schweitzer. Also at this time, I would like to present the George C. Pratt Award. Each year, the Moot Court Honors Board presents the Pratt Award to an individual who has enhanced our legal education through their contributions to the Moot Court program and by their close interaction with our members. The award recipients have demonstrated legal scholarship, professional excellence, and an understanding of the importance of Moot Court in our law school experience. This year, we are happy to present this award to the Honorable Mark Cohen. Each year, Judge Cohen provides Moot Court with incredible support by mooting us for competitions, both in his courtroom and in the school. Judge Cohen has expended much time in helping us prepare for these competitions, and we could not be as successful as we are without him. So on behalf of the Moot Court Honors Board, thank you so much for all of your continued help and support, and we honor you with this award. At this time, I would like to invite the judges to give their feedback, if there's any, and announce the winner. Thank you.
All right, I understand that the tradition here is for to give the judges an opportunity to give you some constructive thoughts and then to announce the winner. We were prepared to do it the other way around, but I'm going to, comply with your preferences. And I mentioned before we have Judge Stong here now with us, and I want to assure you that she did not vote. But she's prepared to make some comments and to contribute, and we'll hear from her, I guess, last. And at this time, let me just say before I call upon my colleagues to be more specific, that I have the privilege periodically to be invited to participate in moot court competitions in many different forums. And I'm sincerely terribly impressed with Touro Law School. I have an affinity to Touro because I was teaching a class at Touro Law School way back when. It's 19 years ago when I was interrupted because I was told the White House was calling and they wanted me to be a federal court judge. So am I forever linked? And you should have seen the look of the students' faces at that particular time when I had to excuse myself to take that phone call. So I've had wonderful experiences and a wonderful, rich history with Touro. The last time I met Touro was in Nassau County when I was on the panel of judges who had to decide who would be successful in their moot court competition. And if I remember, they were competing against St. John's, I think Fordham, I think Hofstra, and they came in 1-2. And it was just a terrific, a wonderful experience for the Touro competitors. So you folks really, obviously you're getting very good faculty guidance here, are becoming really battle tested here in many ways. And when I know that some of you had to come here or, it was required, but I have a sense that you would be supportive of your moot court competition even if you were not so-called required to do so. But I've been to other schools where just a handful of people would come to support their teams, and you people have a lot to be proud of. And I can tell you that because I have the comparative experience to share with you. So it's just wonderful to be back here in my home and to see this wonderful, crowd. With that, let me call upon I guess it would be the first Judge Freedman to maybe make some comments that you could share with the students.
I do want to point out that the student turnout is very impressive for this competition. I want to be positive towards both contestants because I feel that both of your presentations were very well done. Very fluid argument, good eye contact. You knew the case very well. To try to give some constructive idea, I think Sidney Goldstein made some record references which in a real argument would have been countered by other matter in the record. So when you pick something out of the record, you have to consider what else there is in the record which may be contradicting the point that you're making, whether you even want to focus upon it. But her argument was certainly outstanding, and very well done. And the same is true for Jason Prince. In terms of being constructive, I thought that he didn't do enough with the 6 factors. He didn't hone in on it and hone in on the factor which would really make his case. So could use some work in that area. Also, as to the response, I think that the response should have been a more powerful point as to one central factor why you should win. That's to Ms. Goldstein.
All right, and the next Judge Freedman.
I concur that both of you really did an excellent job, and we see a lot of lawyers arguing before us, and you are going to do very well if you go into appellate arguing, I can assure you, both of you. You both, as Judge Friedman said, made eye contact. You were fluent. You were very knowledgeable about your cases. Just one thing. Jason, I thought, frankly, if you could have, I would have gone with the second issue first, because I think that was your stronger issue in this case, the policy, sexual abuse of a child. I mean, that's really powerful. The other argument was a little harder because cases have gone all over the place as to who constitutes a minister, but you did have them, and I thought you handled them well. I agree you might have honed in on a couple of the other issues. You were also both good at deflecting some of our questions that were maybe a little off. Judges do that. They ask questions that are not quite on point, and you have to answer them, but you have to then get back to your main point and say what you wanted to say. And if you can use what the judges asked to get back, so much the better. Otherwise, just get back to it. Some questions are almost impossible to answer when the judge asks them, and you just have to then proceed with your argument as you plan, but some other judge is going to say to you, well, answer the judge's question, so you still have to answer the question. I agree. I would have done a little more with the reply. That's when you hone in and really give it to the other side. But you were very good. You were very poised. Both of you were poised. You looked at us, and you made your arguments well.
Well, I echo these thoughts also, but I want to just comment that I have a lot of oral arguments in court, as, of course, our distinguished appellate judges as well. And trust me when I tell you this, you've done as well, if not better than 99% of the lawyers that appear before me. You should feel very good about that. You're being well trained. Your composure is excellent. I'm talking to the two of you, and you just were superb. I want to critique myself first, you see, to pay attention to detail. I didn't pay attention to the detail that Sidney was a woman and not a man, right? So I can't be too critical if you're not paying attention. You mentioned the record, which sounds effective. It sounds like, wow, this person's really on top of things. Some people like it. Some people look upon it as overkill. And it's very hard to really know how a judge is going to respond because sometimes we're inappropriate too, obviously, I have to admit that. And how you handle it is all very, very interesting. When Ms. Goldstein was told by me to answer the question, of course you have to answer the question. It's one of the things that sometimes lawyers really want to avoid like the plague if they don't like the question, but you have to, and it's a common type of thing that comes up. But your recovery was terrific. You apologized, you went right on, you weren't shaken by that. And when, we question lawyers at oral argument, it's not that we're trying to throw them curveballs, but the judge is interested in things which may not be pro forma. You want to get to the underbelly of things. I put myself in that role intentionally by trying to ask you questions about which one of these factors dominate, 4 out of 6 and things of that nature, to try to not throw you off, but to try to at least get you to focus on things which perhaps you haven't thought about, and to see how you would deal with that. And I thought, by and large, you did well. Once again, Mr. Prince, remember, when you're going to argue, you have a limited time, whether it's before an appellate court, whether it's before me, sitting, listening to oral argument on a 12B6 motion or a 56 motion. Go with your strongest suit. Lead with the best that you have, because the tendency is that what you speak about first will probably take more time in the real world than maybe you want to give to that issue. So don't go with your weaker point, because that may last 20 minutes. You may have 5 or 10 minutes to talk about your strongest point. And here, I guess you had the discretion. You weren't committed to arguing the points in any particular order. And as Judge Freedman pointed out, you had a real strong issue that you could have pounded the table on. And so try to remember that when you're going to be orally argued, try to get the court to focus on your strongest point. Maybe they'll forget about the weaker point, or the emphasis won't be in that direction. So just to wrap it up, I'm going to call upon Judge Stong, who's a colleague of mine, sits in the Bankruptcy Court in Brooklyn. I know she got 4 speeding tickets coming out here, and she's going to have some thoughts, I guess, to share with you, even though she unfortunately wasn't able to participate in the wonderful moot court competition.
Thank you so much, Judge Block. It is a real privilege to be here, even in this capacity, to share this evening with you, to have had the opportunity over the last couple of weeks to wade into the materials and to, I'll say, share this bench with these dear friends from so many different parts of my career. It's really special for me, so I thank you so much, and I hope you'll be kind enough and forgiving enough to give me a second chance and invite me back. I learned this today, and I sit before you as the trial judge, first instance judge. We in the bankruptcy court in the federal system do not, unlike my revered cousin on the bench in the district court, Judge Block, we don't sit by designation on courts of appeal, nor are we appellate judges, of course. And so I am the only judge on this panel who does not ever, except in moot courts, sit as an appellate judge. And here's what I learned today, as I was stuck in traffic coming here. Unlike a trial court, which cannot start without me, the appellate court can. Now, I'm not sure if this is a good thing or a bad thing. As my courtroom deputy likes to say, you can't start Hamlet without Hamlet. Unlike Hamlet, I try to be very decisive. But this court could start, and thank goodness for that. I thank again my colleagues for that. I learned that. I didn't vote, of course, but I do have a couple of votes that I think I have the prerogative to cast. And the first one is the materials. If you had anything to do with these fabulous materials, could you raise your hand? Just fabulous. How many briefs do I read? I had 129 matters on my calendar yesterday. My first matter this morning at 8:30 had 15 of the largest law firms in New York City, $7 billion reorganization of a fairly large company. I read a lot of briefs. These materials are fabulous. The question was interesting and engaging. The materials were very well presented. Thank you for the opportunity. You have my vote on that. Here's another place where I can cast a vote. I teach at a couple of law schools in the area, and I'm lucky enough to be with law students and lawyers from time to time, including, as I've gotten to know your fabulous and amazing dean from time to time in bar associations. Let's hear it for your fabulous dean, by the way. There is a kind of energy in a room when lawyers and really smart law students understand that they are part of a community, and the community is the person they see in front of them, behind them, to their left and to their right. And when I walked into this room, pathetically late as I was, the one thing I knew immediately was I was part of a professional community. You guys get it.
You get it. The energy in this room could have been scooped like ice cream. It was tremendous. Keep at it. Don't forget it. Look around the room. Look up at people up there too. The best thing about this profession, and I hope you love this profession as much as I do your entire career, is your colleagues. Whether they're your adversaries, whether they're your co-counsel, whether they're your in-house counsel client, whether you're the judge and they're appearing before you, whether you're the law clerk and they're the judge, whether you're the judge, yes, it can happen to you. No one ever said that to me at my law school. These are your colleagues. This is your professional community. Hold on to that energy. Show up for each other. Be there for each other. Please don't ever forget that. Thank you for that, too. I can cast that vote. As I was thinking about the arguments that we'd be hearing today, and as I think about any argument, I like to think, and I like to think in the 20 years that I was a litigator, that a good argument is really a conversation. An argument sounds scary. Conversation is something you do every day. And when you really develop your skill as an advocate, you will feel comfortable at that podium that an argument is a conversation with the judge. And maybe a little bit with your adversary if you're thinking about a settlement too. But first and foremost, an argument is a conversation with the judge. What do you look for in a good conversation partner? Someone who says interesting things. Someone who's a good listener. Have you ever had a conversation with someone who's not listening? You say something huge and profound. They say something irrelevant. You don't like it. Neither does the judge. It's not responsive. You may have to manage a question if the question goes to your weakest point. Sometimes the lawyers I most admire are the ones who acknowledge the weakness. Yes, you're right. That's a difficult case for our side, but here's why it's not controlling, judge. Some judges prefer the Your Honor. Judge, Your Honor, either one works for me. But it's a conversation, so listen. I'm sure you did. I've heard you were fabulous, by the way. Listen, pause, think, respond. Be about something. Have a point. When I prepared for arguments, I wasn't done till my notes were down to one page. And I knew what I was going to say at the beginning, and I knew what I was going to say at the end, and I had bullet points in between. But be about something. If you have a point distilled for your argument, then no matter how hard the question, you're going to have something productive to say in response. Remember the destination. If you're about something, if your argument is a point, every answer will move you closer to that. Know your beginning, know your ending. Yes, I will end soon. Keep it down to one page. I was authorized by our panel to give you the opportunity to indicate, and the decision's already made, so you don't have to worry. This is no prejudice. Is there a question you wish the judges had asked you tonight? What do you think, Mr. Prince?
Well, that'll end all conversation for sure, right? But
what question do you wish the judges had asked?
anybody wish to volunteer?
I'm sorry, go ahead.
The most favorable factor, or the factor that supports my side the best, I wasn't expecting. I guess I was kind of expecting, but I would have liked to have been asked.
What?
Which one?
Which one?
Which factor most supports my
What
side?
would you like to have been asked?
Which factor most supports instead
Which
of
of the factors of the analysis most supports?
What's most helpful to you?
I think I was getting at that. I think I gave you the opportunity to answer that. But
Oh, Judge Block, be fair.
I thought I did too.
The oral argument part's over.
anyway, I think the dean would want to say a few words at this particular time.
Ms. Goldstein, what question do you wish you'd been asked?
Well, that was your main point, so get it in there.
Well,
Okay,
enough about me. Thank you again.
Dean Salkin.
And so, first and foremost, I'd like to thank my colleagues on the bench for offering very sage and priceless advice to all of us, not just to our two competitors this afternoon. And, you know, last year was my first Bainbridge competition, and I left thinking, how is anybody ever going to compete with the great Christina Noor and Paul Lipsky? Who were great role models for both of you and for your classmates, and you guys did it. You did a great job, and you carried on in the tradition of being a role model for all of the 1Ls that are sitting here thinking about what it's going to be like to sit in your seats next year. So I want to congratulate you for doing that. You both were poised. You both were passionate about your arguments. It was clear that you knew the case, you knew the record, you knew the facts, you knew the cases that were both for and against your position, and you cited them with ease. I thought that was terrific. I thought it was also great that, as Judge Block said, there were some questions that kind of got you to stray from where you wanted to go in your notes, and we certainly, this was a hot bench. You didn't have a lot of time to get back to where you were, but I think you did go back right away as soon as you could catch your breath, because this bench just kept firing questions, and that was difficult. And sometimes, last year, I remember that there were gaps of time where the students could go back and really get into their own arguments. And here you were not driving the bus, the bench was, and I thought that you did a really great job of trying to keep up with us. I thought you were both great in being able to acknowledge each member of the bench as they asked a question. You repeated the name of the judge back. I thought that was respectful and good, because that's easy to forget. You were mindful of the time. There's always the pressure of the timekeeper. Sometimes it's a light at the podium, but I thought that that was great. You were respectful when Judge Block said time's up, and you asked, would you like me to finish answering the question or not? So at least you deferred to the bench with that, and I thought that that was really terrific. Judge Freedman started out with a comment about the record, and we actually talked about this in the back room, and I noted that last year there was actually a lot of positive feedback that Christina and Paul referred to the record during their arguments, and that was a good thing. And so there was some disagreement, and again, I think the feedback from Judge Freedman is just be careful, because the other side can pick up on it and it could be used against you. Of course, we didn't have the full record to refer to the pages in front of us now, so I'm not sure if it was a good thing or a bad thing. I think it's generally positive as long as you know what you're doing. So I think I just want to conclude saying that you guys both did a terrific job, and you should be proud of yourselves. And for all of the 1Ls here, this is what it's all about. This is what it is under pressure. This is why you stand up in class, why the faculty ask you questions that sometimes you can't understand how they relate to the case, or it's not what you were prepared to talk about from your brief. It's because you never know what the judge is going to ask in that conversation. I like Judge Stong's characterization of it. So you held your own, and congratulations to both of you.
All right. Before I announce the winner, just let me make one parting comment. You folks are litigators, and 95% of the bar, they are not litigators. We only see in the courts the 3 or 4%, I don't know what the exact percentage is, but a very small segment of the bar that have the guts, the internal fortitude to be able to stand up, objection overruled, objection sustained. You win, you lose, you get yourself up, you go back to your next case. It takes a special type of person to be able to have the emotional as well as the intellectual capacity to deal with that. I really look upon the litigators, which is our world here as judges, as almost like the heart surgeons of the profession. I mean, it's a very difficult calling, but you two have it, and I think that you're well on your way to having a great success in that wonderful, wonderful special area of the law called litigation. At this time, naturally, you know, as people who are exposing yourself to winning and losing, and you're willing to do that, you have the emotional fortitude, we have to pick somebody. You both were terrific, but we decided that by a very, 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 very slight margin that Ms. Goldstein is the winner. Congratulations. We stand adjourned now, and hopefully we'll be able to have a chance to chat with you informally at the reception.